Most people who have a will believe they've protected their family. They haven't. A will is one of the most misunderstood legal documents in America, not because it's complicated, but because nobody ever explained what it actually does and what it doesn't. Here's what I mean. Right now, across America, there are families sitting in probate court, waiting months, sometimes years, to access money that was left to them in a perfectly legal, properly witnessed will. The will did exactly what it was supposed to do, and the family still ended up in court. If you have a will, or if you're thinking about getting one, you need to understand one thing before you do anything else. A will does not avoid probate. In this video, I'm going to show you exactly what a will does, what a living trust does instead, why most people have them completely backwards, and what actually protects your family's money when you're gone. Let's start with what a will actually is. A will is a legal document that tells a court what you want done with your assets after you die. That's it. It's a set of instructions addressed to a judge, not to your family. And that's the key word most people miss: a court. When you die with a will, that will has to be filed with your local probate court. The court has to verify it's valid. The court has to notify potential creditors. The court has to oversee the distribution of your assets. That process, from filing to final distribution, takes time. It costs money, and none of it happens quickly. The average probate case in America takes between 9 months and 18 months. In states with backlogged courts, California, Florida, New York, it regularly takes 1 to 2 years, sometimes longer. During all of that time, your family cannot touch the assets in your estate. Here's what a will does well. It lets you name who gets what. It lets you name a guardian for minor children. It lets you name an executor, the person responsible for managing the process. These are important things. A will is not useless. But a will is not protection from probate. It is a roadmap through probate. Most families don't know the difference, and that difference costs them months of waiting and thousands of dollars in fees. Let me give you a concrete example of what this looks like in practice. A woman in Ohio, she appeared in our last video, the one who walked out of the bank with $83,000 6 days after her mother's funeral because of a POD designation. No court, no attorney, no waiting. Now imagine the same situation, but instead of a POD designation, her mother had left a will that said the same thing: leave everything to my daughter. Same intention, completely different outcome. With the will, that daughter would have filed with the probate court, waited 9 to 14 months, paid attorney fees, and received less than the $83,000 her mother intended. Same person, same money, same wishes. Two completely different outcomes based on one document versus another. That is the difference between a will and a beneficiary designation. And most Americans don't know it exists. Let me show you exactly how this plays out in real life. A couple in Georgia, married 35 years. They did everything right. Hired an estate planning attorney, had their wills properly drafted, witnessed, and notarized. Felt completely prepared. The husband passed away at 74. He had $180,000 across 2 bank accounts and a brokerage account. His will clearly stated everything went to his wife. She went to the bank the following week. The accounts were frozen. She filed the will with the probate court. Georgia's probate process began. It took 11 months. During that time, she couldn't access a dollar of the money her husband left her. She lived on her own savings and Social Security. By the time probate closed, the estate had paid $14,000 in attorney fees, court costs, and executor expenses. She received $166,000 of the $180,000 her husband intended to leave her. The will was perfect. The outcome was not. This story is not unusual. It plays out in probate courts across America every single day. What makes it painful is that it was entirely preventable. The couple spent $1,200 on their wills. If they had spent $2,500 on a living trust instead, or even added POD designations to their bank accounts for free, none of this would have happened. The wife would have had immediate access. The $14,000 in fees would have stayed in the family. The 11 months of stress and uncertainty would have never occurred. One decision, made years earlier, would have changed everything. That is what this channel exists to help you avoid. What a living trust does differently. A living trust, also called a revocable living trust, is a legal structure that holds your assets during your lifetime and transfers them directly to your beneficiaries when you die. No court, no probate, no waiting. Here's the key difference. With a will, you are the owner of your assets until you die, and then the court takes over. With a living trust, the trust is the owner of your assets, and when you die, the trust continues operating and distributes according to your instructions, immediately, privately, without any court involvement. The same couple in Georgia, if they had used a living trust instead of just a will, the wife would have had full access to all $180,000 within days of her husband's death. No probate, no $14,000 in fees, no 11 months of waiting. The three critical differences. 1. Probate. A will goes through probate. A living trust does not. This is the single biggest difference and the one that matters most to your family in the weeks after you die. 2. Privacy. A will becomes a public document the moment it enters probate court. Anyone can read it. Your assets, your debts, who you left money to, all public record. A living trust is completely private. Nobody outside your family ever sees it. 3. Speed. Even a simple probate case takes months. A living trust can distribute assets in days. When your family is grieving, speed matters. The combination that actually works. Here's something most people don't know. You need both. A living trust handles your accounts, your investments, your property, anything you've transferred into the trust. But the will handles everything else. Things you forgot to put in the trust, personal property, and critically, the guardianship of minor children. A living trust cannot name a guardian for your kids. Only a will can do that. The gold standard in estate planning is a living trust as the foundation, with what's called a pour-over will as the backup. The pour-over will catches anything you forgot and pours it into the trust at death. Together, they give your family complete protection. The cost question. A will costs between $300 and $1,500 to have properly drafted by an attorney. A living trust costs between $1,500 and $3,500. Online services like Trust and Will or LegalZoom offer living trust starting around $500. Compare that to the average probate cost of $10,000 to $15,000, and the math is simple. A living trust pays for itself the moment it avoids probate. So what should you actually do? Step 1. If you have a will and nothing else, go back and read it. Understand that it does not protect your assets from probate. It manages what happens inside probate. That's an important distinction. Step 2. Talk to an estate planning attorney about whether a living trust makes sense for your situation. It doesn't make sense for everyone. If your total assets are under $50,000 and you have named beneficiaries in all accounts, probate may be minimal. But for most American families with a home, retirement accounts, and bank accounts, a living trust is the right tool. Step 3. If you're not ready for a full trust review, at minimum, make sure every bank account, every retirement account, and every brokerage account has a named beneficiary. POD for bank accounts. TOD, transfer on death, for brokerage accounts. Beneficiary forms for retirement accounts. These designations override both your will and your trust. They are the fastest, cheapest form of probate protection available. Step 4. If you already have a living trust, make sure your assets are actually in it. This is the most common mistake trust owners make. You set up the trust, you paid the attorney, and then you never transferred your bank accounts or property into the trust's name. A trust that doesn't own your assets does nothing. This is called a fully funded trust, and it's the step most people skip. Let me also address something I hear constantly. People say, I don't have enough assets to need a trust. I hear this from people with $200,000 homes, $150,000 in retirement accounts, and $40,000 in savings. That's $390,000 in assets. If that goes through probate, and without proper planning it will, your family could pay $20,000 to $40,000 in fees and wait 2 years to receive it. The threshold for meeting a living trust is lower than most people think. In most states, if your total estate exceeds $100,000, including your home, a living trust is worth serious consideration. Talk to an estate planning attorney. Many offer free initial consultations. The conversation costs nothing. The ignorance can cost everything. Let me bring this together. A will is a legal document that instructs a court. A living trust is a legal structure that replaces the court entirely. Both have a role. But if your goal is protecting your family from probate, from the months of waiting, the thousands in fees, the public record, a living trust is the tool that does that. A will alone does not. The most important thing you can do today, regardless of where you are in this process, is understand which tools you currently have and what they actually do. Most people are carrying a will and calling it protection. Now you know the difference. In the next video, I'm going to walk through exactly how probate works in practice, the timeline, the real costs, and why families in states like California, Florida, and New York are hit the hardest. If you live in one of those states, the next video is something you can't afford to miss. I'll see you there. If you found this video useful, don't forget to hit like and subscribe. It helps more families find this information.